Thanks everybody for joining. We'll get started in a few minutes.
Gracias a todos por unirse. Vamos a comenzar en unos minutos.
All right, I guess let's get started if you want to provide the instructions.
Thanks, Kitty. Hello, everyone. Hola a todos. My name is Emiliano, and along with my coworker Ladna, I'll be providing English to Spanish simultaneous interpretation today. Mi nombre es Emiliano y con mi colega Ladna voy a estar proveyendo interpretación del inglés al español y viceversa de forma simultánea. So a few instructions for everybody. Algunas instrucciones para todos. We are holding this meeting bilingually to ensure language justice, which means that everyone will be able to listen to and participate in this meeting in their language of fluency. In one moment, all participants will need to click on the globe on the bottom of your Zoom screen and then select your language of preference and click Finish. If you are connected by phone or tablet, you will need to click on the three dots or the word More to find the language interpretation option. During the meeting, everyone can simply speak in their language of preference. Everyone will be able to hear you. When you hear someone speaking in a language you don't understand, you will also hear the interpreter speaking in your language of preference. We haven't turned this feature on, and I'll let you know when we're about to turn it on. Esta reunión se ofrece de manera bilingüe para asegurar justicia lingüística, lo cual significa que todos pueden escuchar y participar en esta reunión en el idioma que más dominan. En un momento, los participantes tendrán que dar clic en el globo situado en la parte inferior de la pantalla, seleccionar el idioma que dominan mejor y seleccionar finalizar. Si están conectados por teléfono o tableta, primero seleccionarán los 3 puntos de más opciones para poder seleccionar interpretación. Durante la reunión, las personas de habla inglesa deben hablar en inglés y los intérpretes se expresarán en tiempo real en español. Los hispanohablantes deben hablar en español y los intérpretes lo harán en tiempo real en inglés. Todavía no se ha prendido la función. En un momento les aviso cuando lo vamos a aprender. Interpreters are typically 3 to 4 seconds behind the speaker. So please remember to pause before responding to another speaker to allow interpreters to finish catching up. The interpreters may write in the chat, please slow down, please speak up. You may see us do this. This means to slow down. We will need the support of the meeting hosts to read those meetings aloud so that the speaker is made aware. Los intérpretes típicamente están 3 a 4 segundos detrás del orador. Entonces, por favor, pausa antes de responder a otra persona para permitir que terminemos de interpretar todo. Podremos escribir en el chat, por favor, hablar más lento, por favor, hablar más fuerte. También nos puedes ver hacer esto. Esto significa hablar más lento. Entonces pedimos el apoyo de los anfitriones para interrumpir al orador y leer nuestros mensajes en voz alta. And I think with that, we are ready to turn on interpretation. Ya estamos listos para aprender la interpretación.
Okay. All right, great. We should have interpretation going now. Thanks everybody for joining us today. My name is Katie Witchett, and I'm a senior staff attorney at Legal Aid at Work. Good to see all of our attendees. A lot of you have attended our trainings before, and I'll pass it to Natalia to introduce herself.
Hi, everyone. Thank you so much for sharing your time with us today. My name is Natalia Gottschalk. I'm an advocate with Legal Aid at Work's Work and Family Program.
So today we'll be going through workplace rights for people who are pregnant, new parents, and family caregivers, specifically in California, with a focus on paid leave and accommodations. So those rights that people have to changes at work or time off from work so that they can care for themselves and their loved ones without having to sacrifice their jobs. As some background about Legal Aid at Work, we're a nonprofit based in San Francisco, but we serve folks all across the state. Our focus is workplace rights. So we have specific teams that focus on different aspects of rights in the workplace. So we have a team that focuses on racial and economic justice, a team that focuses on addressing wage theft, and a team that focuses on gender justice at work and many other topics. So if there are rights related to the workplace that you want to learn more about or offer people support in accessing, feel free to check out our website for information on our other programs. Natalia and I specifically are a part of our work and family team, where we focus on empowering workers who are parents, pregnant family caregivers, or caring for their own health so that they can keep their job, have an income, do what they need to for themselves and their family without having to sacrifice their job, which we know is important for family well-being and for health and for so many different things. So as far as how we do it, there's a lot of strategies that we use. So first, we have a free and confidential work and family helpline, where if people call us, they can speak with an attorney or a legal advocate to get information about their specific circumstance or question. So whether they're having a hard time getting pregnancy accommodations at work, they don't know how much time they can take off, or if somebody's a social worker or a healthcare provider who's trying to support a patient and has questions about their rights. Our services are available to people who earn lower wages, as well as those who support them in healthcare and other social services. Beyond providing advice on a helpline, we also represent workers. So that can involve helping them figure out how to communicate with their employer. It can involve us writing a letter to their employer on their behalf, asserting their rights. And we also file cases in court and help people with filing complaints with different administrative agencies. So what any one individual person needs to make sure that they can enforce their rights and feel safe at work can vary. And that's something that we always talk with the client or caller about to make sure that we're keeping them centered and their goals centered in our work together. One thing that you'll notice throughout the training is that some of these rights are not exactly what we want them to be. So another big part of our work is advocating for stronger workplace rights and protections. So we'll highlight throughout today some of the ways that laws have changed based on that advocacy. And when we talk with providers or when we talk with workers and we see new gaps and see issues coming up where the law doesn't address their needs, we try to highlight that to government, the legislature, different agencies, so that we can make sure that our systems keep all Californians in mind, and especially those from the most marginalized communities. We also create educational resources to make sure that people can learn about and understand their rights and their patients' rights outside of having a one-on-one conversation with us. And we'll highlight some of those later on. But all of the work that we do is rooted in our strong belief that nobody should have to choose between their job and their income and their health and the well-being of their family. So just to center us a little bit before we get into the substantive rights, we want to talk about why paid leave is so important. It's something that's connected with a lot of health benefits for families, workplaces, people who give birth, and children. Just some of the examples are that it's associated with decreased stress, anxiety, and depression for people who have babies. It's also associated with increased breastfeeding and chest feeding. for babies. It's associated with improved bonding and reductions in child abuse, and also increases in the rates at which they receive the immunizations that they need and preventative care. For families, it can play an important role in helping parents maintain their employment and economic stability, and also promoting gender equity by making sure that when families have babies, all of the parents are able to be there at the start and to form connections and learn habits to support their families going forward. And in terms of the workplace, it's also really good for employers because I think we all know that people who have families are some of the best employees and are great workers. And by having policies that allow people to take care of their families and also be employees and also be productive, it allows employers to keep their workforce and have better morale and productivity in the workplace. While we'll be covering all of the rights that are critical for working families related to family caregiving, bonding, and pregnancy, I also will be highlighting some of the ways that the law has changed recently. So fortunately, it has continued moving forward, and there are some exciting new changes in the law for 2025. And the first one, and we'll highlight this repeatedly throughout this training because we're just so excited about it, is that paid family leave and state disability insurance benefits now allow most workers in California to get 90% of their income when they're taking time off to bond or to care for an ill loved one or to take time off to recover and return to work. So that's 90% of their income, almost their full income. Also, starting this year, workers are able to apply for paid family leave. And we'll talk more about what paid family leave is later on when they need it without burning through 2 weeks of vacation first. And then we'll also highlight some of the ways that the law has changed in the last couple of years, because these might be things that folks don't know about or employers are unaware of. So workers might face more hurdles in accessing these rights. So one is improvements in rights to lactation accommodations at work. Another is leave specifically for people who experience a reproductive loss. Another is an increase in the number of paid sick days that workers can receive in California. And then another important one is just for leave to apply to those who work at smaller employers and for folks to be able to take family caregiving leave to care for their chosen family. So meaning, not just a spouse or a child, but maybe an aunt or a cousin or a best friend or unmarried partner. So we'll be digging into each of these a little bit more as we continue through this training. But just to give you a framework of what we'll be addressing as we go forward, we're going to start out with pregnancy and accommodations during pregnancy. Then we'll be moving to how people can take time off and get paid while they're taking time off. After that, we'll look at more rights that are important to families, and then cover a handful of other related leave rights and protections that workers have. And then finally, we'll go through some of the resources that we have available and that you can access online. And at the end, we'll have a good chunk of time as well to answer questions. So throughout today's training, feel free to put questions in the chat or the Q&A section. And we might not answer them in the moment, but we will answer them later on at the end, or you can reach out to us and we can talk offline later if there are questions that we don't have time to get to. We're also recording this training, so for your colleagues who might not have been able to make it, you'll be able to share it with them afterwards. We're also going to have a survey at the end because we always want to do better and make this useful for you and the communities that you serve. So please be sure to fill out the survey when we share it later on. And with that, I'm going to pass it to Natalia to start digging into what some of these rights are. Thanks.
Thank you, Katie. So let's discuss the workplace rights of pregnant people in California. Under California pregnancy disability leave laws, people in California who work for an employer with 5 or more employees have the right to take time off work during their pregnancy. This could be for scheduled prenatal care appointments, and it could also be to address any pregnancy-related symptoms that might be interrupting their workday, for example, morning sickness, unexpected pain, or anything else. The employer can require the worker to provide a medical note to justify their time off. Also, under California's pregnancy disability leave laws, pregnant workers have the right to request reasonable accommodations or changes at work from their employer. They will have to let their employer know that they are pregnant and possibly provide a note from their doctor with the request. Workers who are eligible to request accommodations, workers are eligible to request accommodations if they work for an employer with 5 or more employees, and if the worker is pregnant, if they've recently given birth, or if they're experiencing a health condition related to their pregnancy or to childbirth. Pregnancy accommodations should be specific. An employer cannot force someone to stop working if they are still able to do their job with reasonable changes. As I mentioned, employers could require the worker to provide a medical note along with their request for accommodations. This note should clearly state that the patient is pregnant or is experiencing a pregnancy or childbirth related condition. The note should describe what the patient is requesting and what their limitations are, as well as the expected time period that the accommodation will be needed for. The note should also describe tasks that the patient is still capable of doing at work. The medical note should not disclose a specific diagnosis, and employers are not permitted to require a diagnosis or ask about one. We recommend starting with smaller requests for specific accommodations. So let's look at the case of Mariana, a fictional patient. Mariana is a security guard at an office building. Her job includes standing at the doorway for parts of the day and also patrolling the outside of the building and the parking lot. When she becomes pregnant, she talks to her doctor about feeling tired at work and asks her doctor to write a note requesting accommodations. Mariana is asking to continue patrolling the building and monitoring the doorway with a 5-minute break every hour and a stool to sit on when she's staying in one place. So as you can see, her requests are small, specific to her need for rest, and the note describes tasks that Mariana is still able to perform at work. With these accommodations, Mariana can still watch the door, patrol the building, and keep doing her job. Pregnant workers in California are also protected from discrimination at work related to their pregnancy. Their employers can't treat them worse just because they're pregnant. This applies to hiring, firing, pay, benefits, promotions, and demotions. It also applies to scheduling and hours. Employers cannot change pregnant workers' schedule or reduce their hours just because they're pregnant. Employers also can't force pregnant workers to stop working or go on pregnancy leave if the pregnant worker is still able and wanting to work. And the employers cannot create a hostile work environment for the pregnant employee. Returning to Mariana's case, here are some examples of discrimination that she experienced from her employer. First, as Mariana's pregnancy advances, her supervisor reduces her hours and started shortening her shifts. Mariana is still able to work and wants to work her full hours, so this could be an example of Mariana's supervisor discriminating against her based on her pregnancy. Second, the supervisor refuses to consider Mariana for a promotion, and she tells Mariana that it's because she will be taking maternity leave soon. Finally, the supervisor forces Mariana to begin her pregnancy disability leave early, despite the fact that Mariana can still work and still wants to work. And so at this point, Mariana can call our helpline and talk to our legal team for support. So I'll pass it back to Katie, who's going to talk about leave from work and pay during leave.
Thanks, Natalia. So as Natalia mentioned, we discussed what rights folks have while they're pregnant at work. But of course, folks often end up needing time off from work when they're pregnant or have a baby as well. So we're going to move on to talking about how someone can take leave from work and how they can get paid while they're taking that leave. So I'm going to say this way too many times throughout, but we're going to be talking about leave, which is the right to take time off. Sometimes I'll call it job protected leave. And then we will also be talking about pay during leave. And while ideally somebody can take time off and know their job is safe and get paid, in California, we have two separate sets of laws that provide each of these rights. So in order for somebody to take time off and know that they can return to their job at the end of it, they don't have to worry about being fired based on the fact that they need time off, and to get paid so that they're not dealing with a sudden loss of income while they're pregnant or encountering a health crisis, they need to have both of these rights in mind. So we'll be talking about them separately and also continuously flagging which one it is that we're talking about. So sometimes we'll use this little lock symbol that you can see on the screen to show that we are talking about job protection, the right to return to somebody's job after leave. And then we'll use that little cash symbol when we're talking about wage replacement. So how somebody can get paid while they're taking time off from work. So starting off with pregnancy, in California, pregnant workers have the right to job protected leave under California's pregnancy disability leave law. So it's something that requires employers to hold somebody's job, but not necessarily to pay them when they cannot work because of their health related to their pregnancy or childbirth. So what pregnancy disability leave provides is the right to take time off from work for one's health related to pregnancy and pregnancy-related health conditions, like recovering from childbirth. Pregnancy disability leave is available to anybody who has an employer with at least 5 employees. So even smaller and mid-sized employers are covered by pregnancy disability leave. And importantly, there isn't a tenure or hours requirement for this protection. So even if somebody started their job a day ago, even if they work only a handful of hours a week, if they are an employee and their employer has at least 5 employees, they can qualify for pregnancy disability leave. Pregnancy disability leave can last for up to 4 months. But it's limited to when somebody cannot work because of their pregnancy or recovery from childbirth or a related health condition. So for many folks, they're not going to be disabled from working for 4 months. It'll be a shorter period of time. But the reason that the law provides for up to 4 months is to make sure that if somebody does need to start their leave early because of health complications, or maybe because they have a very difficult job, or they take longer to recover, they can know that their job will be safe. During the time that somebody takes pregnancy disability leave, their employer must continue their health benefits if they provide them in the first place. So in terms of what pregnancy disability leave tends to look like, in an uncomplicated pregnancy, workers will qualify as being disabled from working 4 weeks before their due date and 6 weeks after for a vaginal delivery or 8 weeks after for a C-section. So again, this is just in a typical uncomplicated pregnancy where somebody will qualify for at least these 10 weeks or 12 with a C-section where they cannot work because of their health. And so this time is, as I mentioned, specifically about the worker's health. So it doesn't take away from time that somebody could spend with their baby later on. It's only about whether that worker is able to work with their own health condition. And so the reason for that is to make sure that people take this leave when they need it. Taking time off before somebody gives birth isn't sacrificing time that they could spend with their baby later on, because pregnancy disability leave time is only about that worker's own health, not about bonding with their baby, not about their baby's health. So as I mentioned, some people might qualify for leave earlier on if they have a complicated pregnancy or work in a very difficult job where they cannot be accommodated. And it can also be used for prenatal care. So if somebody has prenatal appointments, they can use this to take time off and to know that their job is safe. And it also doesn't have to all be used at once. So somebody could take time off earlier in their pregnancy if they're having, like a really difficult time with morning sickness, go back to work, and then continue working until later in their pregnancy when they again require leave. Importantly, employers can require a medical note for pregnancy disability leave. But again, it doesn't need to be detailed. It doesn't need to have specific diagnoses, but it does need to state that somebody is unable to work because of pregnancy and or childbirth or a related health condition, and the anticipated start and end date of that leave. While pregnancy disability leave lasts for 4 months, there are circumstances where somebody might be disabled longer, and there are ways that people can sometimes get additional leave if they have an especially complicated pregnancy or recovery from childbirth in terms of their health. But if that happens, employers can be allowed to ask for additional paperwork. So if you have questions about that, feel free to check out our resources or contact us. But if it's under 4 months, that's when the employer is not allowed to ask for a diagnosis. And the note can be simple and just state when they anticipate taking leave and when they anticipate returning. Importantly, employers can require the note 30 days in advance if somebody has notice of when they'll be taking that leave. So it's good to talk to your patient or your client about that leave sometime in advance and provide them with a medical note so that they can make sure that their job is safe. If, of course, the need comes up suddenly, we all know health surprises happen, then the person can't get in trouble for not having foreseen it and provided a note. But if it's something that they can anticipate, that's when an employer can request a note 30 days in advance. And I'll highlight, Sharon just put into the chat a resource that you can check out later, but it's directions specifically tailored towards how healthcare providers are involved in supporting their pregnant workers and accessing these rights. So what I was just talking about was the job protection part. So how to make sure that somebody is not going to be fired and that they can return to their position at the end of their pregnancy. Now we're moving on to how people can get paid during that time, because obviously most of us cannot just afford to not have an income for months. So fortunately, in California, we have a program that's called state disability insurance. And what it does is it allows somebody to get income when they are unable to work because of their health, including if it's because of pregnancy or childbirth or related health conditions. So what this program offers is partial wage replacement. So not somebody's full wages, but a part of it when they are out of work because of their health. For somebody who's pregnant, it applies when they cannot work because of their health. So again, it starts before their pregnancy and it will continue after. It's available to people who are missing out on income because of the fact that they are taking time off for their health. But for people who are unemployed and looking for work, they can also sometimes qualify too if they stop looking for work because they become disabled by their health condition. In terms of what it offers, it provides 90% of income starting in 2025 for those who earn up to about $63,000 per year. So previously, it was only 60% of most workers' income, meaning that they'd have to lose out on 40% and get by with that much less. But now for claims starting in 2025 going forward, it's 90% of income. So most workers will receive almost as much as they would if they were working when they need to take time off for their health. And our hope is that this means that people will be able to take the time off when their healthcare provider recommends it. All of us on the team have spoken with people who really need leave based on their health and based on their conversations with their provider, but they feel like they have to keep working because they can't afford to lose out on the income that they'll use to support their family and their baby. So now folks can get 90%. Every other worker in California will get 70% of their normal wages up to a cap. The first week that somebody applies for state disability insurance, they won't be paid. So that first week is a time where people might use paid sick days or vacation or something like that if they have it. But I do want to be clear that it doesn't mean that people will be paid within a week of when they apply. It can take longer than that to receive benefits after somebody applies. There was a bill this last year to allow folks to apply to the program early so that they don't have as much of a gap where they're waiting to receive their income, but it's still going to take some time to implement that change. So for now, folks cannot apply in advance, and that first week they won't be paid. Really importantly, immigration status and citizenship do not matter for qualifying for this benefit. And immigration status and citizenship don't matter for any of the rights that we'll be talking about today. Similarly, gender identity and sexual orientation also do not matter for any of these rights. Anybody who qualifies can get these rights and benefits. There are some misconceptions around this when it comes to immigration status, because the forms do have a place where they ask for somebody to fill in a social security number. So later on, we'll provide more information about how people can apply if they have questions about what that looks like when they don't have a social security number of their own. Disability insurance benefits can last up to 52 weeks. But again, it's only as long as somebody is unable to work because of their health. So for most pregnancies and childbirths, it's not going to be 52 weeks, but it can last up to that long if somebody needs it for their health. In terms of how to get these benefits, folks apply at the EDD, the Employment Development Department, which is the agency that administers the state disability insurance program. People can use a paper application, which is what we recommend for folks who don't have a social security number. People are also able to apply online. As far as when folks can apply, it's once they have started their leave. So you can't apply in advance. You have to wait until your leave has started. And if folks are not able to apply at the time that they start their leave, they can still apply later on, up to 49 days retroactively, or even later if there's a good reason that they couldn't apply earlier on. For instance, if somebody didn't know about disability insurance benefits even existing, that can be a good thing for them to mention if they're applying at a later date. Importantly, healthcare providers do need to certify that somebody qualifies for these benefits. And in terms of when somebody qualifies, just to put an emphasis on it, it's just if somebody cannot perform their specific job. So it doesn't mean that they are disabled from doing any jobs or that they are going to be disabled for a long time going forward. It's just this person is not able to perform their specific job at that moment. So when somebody would qualify as being disabled, depends in part on what their job is, because someone might have a much more physically demanding job where they can't do that earlier in their pregnancy, where somebody else might have a more a less physically strenuous job and still be able to continue performing that job despite having the exact same health condition as somebody in that more rigorous position. So here's a chart to kind of put together what this looks like. And we'll be coming back to this timeline later on. So this is showing what the timeline is for somebody who is giving birth in terms of when their job is safe, which is on the top half, and what income they can receive, which we have on the bottom. So as we discussed, 4 weeks before somebody gives birth, they'll be disabled from working by their health, which will mean that their job is protected by pregnancy disability leave. And that will continue while they recover from childbirth for at least 6 weeks after their baby is born. During that time, because they can't perform their job due to their health, they can receive state disability insurance benefits, except for that first week that's unpaid. So this again is only the time that somebody gets related to their own health when they're pregnant and have a baby, and in a typical scenario. So later on, we're going to touch on what baby bonding and other time off looks like and add it to this scenario. So just to think about what it looks like in practice, we've got Angela, who is pregnant and works as a cashier at a large drugstore. Her physician puts her on bed rest at 34 weeks for her high risk pregnancy. And we're wondering, can she get time off and can she get pay? So fortunately, the answer for Angela is yes. Because Angela's employer has at least 5 employees and her healthcare provider says she can no longer work because of her health, she can take time off under pregnancy disability leave. And because she's disabled from working, she can also get income through state disability insurance during that time. In terms of what Angela needs to do to make sure that her job is safe and that she can get paid, for job protection, she needs to talk to her employer. And our recommendation is that she give them a note from her medical provider stating that she is disabled from working by her pregnancy and the expected start and end of her leave. To get income during that time, she'd apply for state disability insurance. And her healthcare provider would need to fill out part of the certification stating that she's unable to work because of her health. And with that, I'm going to pass it back to Natalia to talk about baby bonding and family caregiving. Thanks.
Thank you, Katie. So like Katie mentioned, pregnancy disability leave and state disability insurance are specifically for the person who is pregnant and gives birth. So I'm going to talk about a different type of leave, the California Family Rights Act. In California, separate from time off to recover from childbirth, workers who are parents also have the right to take time off to bond with their child, and this leave can also be used to care for others. So you may have heard of FMLA, or the Family Medical Leave Act, which is the federal law that provides job-protected leave. California Family Rights Act, or CIFRA, because of its initials, overlaps with FMLA, but provides better protections and covers more workers. So we're going to focus on CIFRA during this presentation. So the California Family Rights Act protects workers for up to 12 weeks a year while they take time off to bond with a new child. This could be a newborn in the home, and it also extends to adopted children and foster families. Anyone who is a parent to a new child can take time off for bonding. Sick leave can also be taken to care for a family member with a serious health condition, including parents, spouses, domestic partners, children, grandparents, grandchildren, siblings, parents-in-laws, or a designated person. The designated person can be anyone that the worker is close to, like an aunt or a cousin or a coworker, neighbor, or a friend. Employers can limit to 1 designated person per year. And this type of leave can also be used for needs relating to a family member's military deployment or to seek care for one's own serious health condition. For the parent who gave birth, as long as their disability leave is less than 4 months, they can take bonding leave after they've recovered from pregnancy and childbirth or any related health condition. Workers are eligible for this leave under California Family Rights Act if they work for an employer who has 5 employees or more, and if they have worked for this employer for at least 1 year. Also, in the year prior to their leave, the person taking leave must have worked a minimum of 1,250 hours, which works out to about 25 hours a week or so. There's no medical certification required for bonding leave, though there is medical certification required for caregiving leave. One thing to note is that CIFRA was recently extended to in the last couple years to include smaller employers. So please feel free to share our resources with any smaller employers that you know in case they're not aware of this recent change. So California Family Rights Act gives workers the right to take time off with benefits knowing that their job is safe, but there's a separate program called paid family leave that allows workers to get paid during that time off. Even though it's called paid family leave, this program is not about the right to take time off. It's about getting paid while taking this time off for bonding or for caregiving. Paid family leave can be received for a number of different reasons. First, by workers who are taking time off to bond with a newborn or a recently adopted or fostered child. In these cases, paid family leave needs to be taken within the first year of birth or placement in the home of the child. Paid family leave can also be received while caring for a family member, which includes children, parents, spouses, domestic partners, siblings, parents-in-law, grandchildren, or grandparents. Notice here that paid family leave does not provide pay for people taking time off to care for a chosen family or for a designated person. Last, paid family leave can be received while taking time off for needs related to a family member's military deployment. Paid family leave provides 90% of income replacement for those earning around $63,000 a year or less, and 70% for others up to a cap, just like state disability insurance. Like Katie had mentioned with SDI, this is a really significant increase that happened this year, and it will allow many more families in California to take time off for bonding or for caregiving. A lot of people couldn't afford to take time off before and lose 30 to 40% of their income. So this is a really significant improvement. Paid family leave can be received for up to 8 weeks a year. So I'd mentioned before that California Family Rights Act will protect a worker's job for up to 12 weeks, but paid family leave will only provide pay for up to 8 weeks. So some workers will choose to use vacation pay or PTO to cover those last 4 weeks, or they might choose to take them without pay, or they might choose to just not take those last 4 weeks. Just like state disability insurance and like all the rights that we're talking about in this training, citizenship status or immigration status does not affect eligibility for paid family leave. Workers are eligible if they've paid into the program and are taking time off for the reasons we mentioned, regardless of their documentation status. Paid family leave can be taken intermittently. It doesn't have to be taken all at once. It can be taken like a week or two at a time, or even a couple days a week. Any new parent can take PFL, even if another parent of the same child is taking paid family leave at the same time. And then for workers in San Francisco, there is a local law called SFPPLO, or the Paid Parental Leave Ordinance, which provides supplemental pay to parents who are receiving paid family leave. SFPPLO will cover the difference between paid family leave and normal wages up to a cap for up to 8 weeks. And there's a link here for anyone who would like to read some more about this. So again, similarly to state disability insurance, applications for paid family leave are available through the Employment Development Department, or the EDD. The application is available online, and there's also an option to request a paper application. People can apply for paid family leave as soon as their leave begins, or up to 41 days retroactively. If necessary, workers can apply after the 41 days if they have a good cause. And not knowing about paid family leave counts as a good cause, including if, for example, an employer doesn't inform the employee that they might be eligible for PFL. There's no medical certification required for paid family leave for bonding, but the EDD will require the parent to submit proof of birth or placement of the child in the home. And medical certification from a healthcare provider will be required for those receiving paid family leave if they're providing care for a family member. So let's review what we've covered so far. California has different protections and programs that cover taking job protected time off work and receiving pay while off work. People who are pregnant and giving birth have the right to take time off work under California Pregnancy Disability Leave, and they can receive pay while off work from state disability insurance. Parents bonding with a new child and family caregivers have the right to take time off work under California Family Rights Act and can receive pay while off work from paid family leave. So let's look at how it all fits together. This chart shows all of the different laws and programs that we've talked about for the person who's pregnant and gives birth. It's an expansion of the chart that Katie shared earlier. So as you can see, the smaller circles are representing time elapsed in weeks. The little orange circle is the birth of the baby. People who are pregnant, who have a pregnancy without complications, can have the right to begin their pregnancy disability leave 4 weeks before the due date, and this leave continues for 6 to 8 weeks after the baby is born. During this time off, the worker's job is protected by pregnancy disability leave, and they can receive pay during their leave from state disability insurance. The first week of state disability insurance is an unpaid waiting period. After that disability leave has ended, the worker can begin their baby bonding leave, protected for up to 12 weeks by the California Family Rights Act, the orange. And then for up to 8 of these weeks, the worker can receive pay from paid family leave, and if they work in San Francisco, also from SF-PPLO. And then this chart shows how these laws and protections fit together for a parent who has not given birth. They have the right to take time off with benefits and job protections for up to 12 weeks under California Family Rights Act and can receive pay for 8 of these weeks from paid family leave. For workers in San Francisco, SFPPLO will provide supplemental pay. And then even though the little orange bubble on this chart says birth, families welcoming an adopted child or a foster child also have the right to these protections and programs, and their chart would look like this too. And then very similar to the previous one, this chart is showing how things fit together for people who are taking time off to care for a family member. They have the right to job protected time off under California Family Rights Act for up to 12 weeks. And during that time off, they can apply for and receive pay from paid family leave for up to 8 weeks. So returning to the case of Angela, let's discuss what happens after Angela has her baby. The doctor clears her to return to work after 6 weeks of pregnancy disability leave after the baby's born. She works for an employer with more than 5 employees. She's worked for them for 3 years, and she works 32 hours a week. Can she take more leave with pay? So yes, she can. She has the right to up to 12 more weeks of job protected time off under California Family Rights Act to bond with her baby. She is eligible because her employer has more than 5 employees. She's worked with them for more than a year, and she's worked more than 1,250 hours, or approximately more than 25 hours a week in the year before her leave. She can apply for and receive paid family leave for up to 8 weeks, and if she works in San Francisco, she can get SFPPLO, and she should apply as soon as her bonding leave begins, and she'll need to send proof of her baby's birth. So what steps does Angela need to do to keep her job safe and get paid? First, she's going to want to give her employer a note saying that she's taking California Family Rights Act leave. The note should specify the start and end date of the leave. Second, she would apply for paid family leave. If she's already receiving state disability insurance, she might get a notice from the EDD asking if she wants to start her paid family leave as soon as her state disability insurance ends. And then finally, if she works in San Francisco, she would talk to her employer directly about supplemental compensation under PPLO. Another example is the case of Terry, who's a new grandparent whose grandchild was born prematurely at 24 weeks, and she's needing to spend some time in the NICU. Terry is a welder. He's worked for a very large construction company with many employees, full-time for over 12 years. Can Terry take paid leave? Yes, he can. If Terry's granddaughter has a serious health condition and is requiring care, Terry can take up to 12 weeks of time off with job protection under California Family Rights Act. Because Terry is caring for a seriously ill family member, he can also access income through paid family leave for up to 8 weeks. So what steps does Terry need to do to keep his job safe and get paid? First, he's going to want to write a note to his employer stating that he's taking time off under the California Family Rights Act to care for his seriously ill grandchild. He should include the dates that he's anticipating that his leave will begin and end, and his employer might require him to submit a medical certification from his granddaughter's doctors. Second, Terry should also apply for paid family leave with the EDD, and his granddaughter's healthcare provider is going to have to fill out a certification for his application with the EDD. And now I'll pass it back to Katie, who's going to discuss other rights and protections for families at work.
Thanks, Natalia. So in the last little while before we get to questions, I'm going to cover some other workplace rights that are important to families, and then other related rights to paid leave. And for all of these, there's so much to know. So if you have more questions, feel free to check out our resources, look it up online, visit state agencies, resources, call us, but we want to at least touch on these rights. So one of them is lactation accommodations. So people who are lactating have the right to reasonable break time when they need for pumping and lactating. So it's specifically not set as a limited amount of time or a specific length, recognizing that it might be different for everybody. So it's just whatever amount of time is reasonable. However, if it's outside of somebody's normal break times, their employer does not need to pay them during their lactation breaks. Employers also need to provide a place for them to pump that is not a bathroom, that is private, that's safe and clean and free of hazardous materials, and also that has a surface to put a pump on, that has a place to sit, and access to electricity, refrigeration, and running water nearby. So a supply closet is not going to work. It needs to be usable, have a place to sit, have a place to put a pump. For some smaller employers, if they have really significant difficulty in accomplishing or creating a room that has one of these elements, like access to electricity or running water, they might be able to be exempt from providing that specific part, but they still need to provide a space, and all employers need to make an effort to make sure that it complies with these standards. Also, employers all are required to have a written lactation policy. So this is a law that's not super new, but sometime in the last 5 years. So there's a lot of employers that don't have a lactation policy. But the idea is to make sure that they've thought about what pumping at work could look like before an employee is coming back and has questions. So for folks who are about to take leave for their pregnancy or currently on their leave, if they're interested in pumping when they go back to work, I always suggest that they ask their employer for that policy ahead of time so that they can figure out what it will look like, identify if there are going to be any issues, and work it out with their employer ahead of time so it's not a surprise that comes back on the first day that they're returning. Employers are not allowed to retaliate against people or discriminate against them for seeking lactation accommodations, and no medical certification is required, but it can be helpful to provide one, just so that folks have more ways of asserting their rights. In San Francisco, workers have an additional important right, which is to accommodations or changes at work for family caregiving, including childcare. So employers in San Francisco, at their employees' request, are required to provide these accommodations. like working remotely or working at a different location, or maybe adjusting start and end times to line up with daycare pickup, unless the employer can show that it would be extremely difficult for them to do so. The Office of Labor Standards Enforcement has great resources explaining more. So this is only for people working in San Francisco. Other rights and protections that are worth being aware of include the right to reproductive loss leave. So this went into effect in 2024 and gives folks the right to job protected but unpaid time off when they experience a reproductive loss. And it's for not only a person who is pregnant and doesn't end up having a child, but also for anybody who would have been a parent absent the reproductive loss that occurs. So it applies to miscarriages, stillbirths, the end of a pregnancy, but also to failed adoptions, failed surrogacies, or an unsuccessful assisted reproduction. So it applies in a variety of circumstances, and again, to anybody who would have been a parent of the child. We have a fact sheet that digs more into this that Sharon just dropped into the chat. Paid sick leave, also an important and helpful right. It gives folks the right to time off for medical appointments, preventative care for themselves or a family member. After folks can use them once they've been working for their employer for 90 days or more, and they accrue this time 1 hour for every 30 hours worked. Previously, employers could limit employees to using 3 days in a year, but now it's been expanded to up to 5 days in a year, although some cities provide even more paid sick time. Also, employers are required to list somebody's paid sick time on their pay stub. So if they don't know if they have paid sick time, it should be available on their pay stub. Immigration and citizenship don't impact this right either. And this time can also be used for reasons related to safety from violence, including domestic violence, sexual assault, and stalking. So, for instance, to seek medical treatment or receive services like counseling, or to engage in safety planning, relocate, or go to court to seek a restraining order. And this is for an employee, a survivor of violence, and also their family members. Another important right that workers have in California is bereavement leave. So time off when a loved one passes away, where their job will be safe. Their employer doesn't have to pay them, but they do have to let them take this unpaid time off. People who experience domestic violence, sexual assault, stalking, or other violence also have the right to time off and to accommodations. Changes at work to protect their safety. The time off could be to go to court or to seek services. And starting in 2025, their family members also have the right to time off for reasons related to safety and recovery. So if somebody's sister is living in an abusive household and she wants to move out of that home, the sister could take time off with her job safe to move, and you could also take that time off to help your sister move from that home, or for instance, to go to court with a loved one seeking a restraining order, or to otherwise help them in their recovery. California also has the Family School Partnership Act, which allows people to take time off for seeking, like enrolling their kid in school or daycare, also participating in school activities like field trips or going to a school play, and also for emergencies. So if a school is shut down due to fires or floods or something like that. And we have more information about that on our website. It's the Family School Partnership Act. To touch on this again, undocumented workers are able to access all of the rights that we have discussed, and they are able to qualify for and receive paid family leave and state disability insurance. However, we have instructions on how they can best apply to provide the information that the EDD needs without having to make any false statements in the process of doing that. So please feel free to check out this resource on how to apply. Also, again, LGBTQ plus workers qualify for all of the rights that we've been discussing. These rights are available regardless of gender identity or sexual orientation. We also have a resource specifically for LGBTQ plus parents on their rights as parents around taking care of sick kids and things like that. Federal workers do have different rights. They are not covered by the California laws that we are discussing today, but they do have different and separate protections that apply to them. We have a fact sheet on the rights of pregnant and parenting federal employees, and other information is available elsewhere online, or feel free to reach out with questions. And with that, I'm going to pass it to Natalia to quickly go through some of the resources that we have available. Thank you.
Thanks, Katie. So yeah, Legal Aid at Work has a huge database of free resources, all available on our website. Most of these are available in multiple languages. Many of these can be ordered in print. We're going to highlight some of them here. And then we've been also sharing the links to them in the chat. And then also as a reminder, we'll be sharing these slides along with a recording of this presentation and all the links to our resources after this training today. So just last month, we completed this guide along with our partners, specifically for healthcare and service providers. It's an excellent summary of all the information we've covered today, and it includes links to certification templates from the California Civil Rights Department, as well as links to sample medical notes drafted by our attorneys. Our Pregnancy Plus My Job resources include a one-page fact sheet for pregnant and parenting workers in California and San Francisco. We also have a roadmap to workplace rights for pregnant workers and an in-depth guide to Pregnancy Plus My Job for pregnant workers to learn all about the protections and programs they may have access to. These are all available online and in print for free. We also recently produced short videos on workplace rights for pregnant and parenting employees in California, and these are available in 12 different languages. Our team operates 2 different helplines. So first I'll talk about the Work and Family Helpline. We provide free and confidential legal advice to low-paid working parents, pregnant people, family caregivers, or we also can talk to healthcare and social service providers who are working with these families. Here's the number and a link to information on our website about our helpline. Our second helpline is for Project Survive. Again, we provide free and confidential legal advice to low-paid workers who have survived or who are experiencing domestic violence, sexual assault, or stalking. Their families and service providers working with these communities can also call this helpline for support. And finally, we have a quarterly newsletter where we share updates on our work, free resources and trainings that we're offering, and news relating to the workplace rights of California families. Please sign up if you're interested. And again, thank you so much for your time. Before we address questions, we just want to ask if you could please complete our brief feedback survey. It's just a couple of minutes. Your feedback's very helpful for us. I believe Sharon already shared the link in the chat, and we'll share it again. And thank you again.
Yes, thanks everybody. We'll give you a few minutes to fill out the survey, and then we'll jump into more Q&A. All right, we have so many good questions. Seems like a good time to start digging into them. If we don't answer your questions here, feel free to email us or contact us, and we can provide more information at a later time. So one of the questions that I'm seeing that's something that comes up frequently is what to do about accommodations when employers are just not interested in providing them, especially for people who are pregnant and have difficult physical jobs. So employers are required to provide accommodations related to pregnancy and recovery from childbirth if the employer has at least 5 employees. If it's related to pregnancy and childbirth, they're required to provide them unless somebody would be completely unable to do their job. So it is true that sometimes we've seen employers don't always follow this, and it's fine to direct people our way. Having a more specific medical note can be helpful. There are resources on the Civil Rights Department's website that explain these rights, and sometimes having a form from a government agency can be helpful too. And given the standard for qualifying for state disability insurance is just that somebody cannot do their specific job, if their employer won't accommodate them and won't make those changes, so that person cannot do their specific job, generally they can qualify for those benefits. So at least there's a way for them to get some income while hopefully they're trying to work it out with their employer to go back to work. That can also be a good circumstance to direct somebody to our helpline, and we can provide one-on-one advice and suggestions for them then. So I'm looking at other questions. There's one about self-employed people and what benefits they will qualify for. So, paid family leave and state disability insurance benefits are available for people who pay into the program. So, folks who are independent contractors are likely not paying into the program and likely won't be able to get those benefits. If they have paid in the recent past, there's a shot. And there's also a lot of people who are being misclassified. So really they should be employees and they should be paying in, but maybe their employer is stating that they're an independent contractor and not taking those contributions out of their paycheck. On our website, we have a resource for folks who think they might be misclassified on how they can challenge that. And then if the EDD finds that they are employees and their employer should have been taking that payment out to pay in, they might be able to qualify for benefits. The EDD also has a program where folks who are independent contractors can choose to opt in to paying disability insurance elective coverage program where they can choose to pay in so that they can get those benefits. But it is much more expensive than it is for most workers. Like all of us just contribute about 1% out of our paycheck. When we get our pay stubs, it's taken out, and it's that insurance that we're counting on. So for people who are independent contractors, they should think about it because for some folks, it may not be worth it to buy into the program, but for others, it might be. All right, I'm looking at questions, and Sharon, feel free to highlight ones that you think would be good to address. We have a lot of really good ones from folks. Okay, I see a good question. Can dad and grandparent take the CIFRA at the same time? So that's a great question. So parents are able to take California Family Rights Act leave, that job protected bonding time or family caregiving time, if they qualify. For a parent, they can take that time for bonding. So if they had a baby within the last year, they can take it. For a grandparent, they would be taking it to be a family caregiver. So if their family member required their care. So it is possible that a parent might take time off to bond at the same time that a grandparent might be taking time off to provide care. The certification that they'd need to give to their employer and that they'd need for applying for paid family leave to the state would need to say that their care is needed. So there'd be a role of the healthcare provider of the baby and saying, is grandparents' care needed? But if it is, then they could certainly both take time off and get paid family leave benefits at the same time. Another great question that's coming up is, can someone take time off to care for family abroad, and specifically to care for chosen family abroad? So these are rights that we're talking about for California workers, but it doesn't matter where their family member is. So they can be traveling somewhere across the world to take care of a sick loved one, and they can be covered if they qualify for these benefits. One of the things that we talked about was how people can take job protected time off to care for chosen family. So like, again, a cousin, a friend, an unmarried partner. But the paid family leave program, so that money that you can get from the state when you are providing care, that does not yet cover chosen family. So if you're taking time off to care for chosen family, your job might be safe, but you won't be able to get income from the state through paid family leave. This is a change that we're hoping will happen soon, because it's, I don't think it's right that people aren't able to take time off and get paid because their family looks different than a traditional nuclear family. But that's the current state of the law. Another great question that has come up is, can a partner qualify for leave to care for a birthing partner's recovery? For instance, the 8-week recovery for C-section versus bonding time, and then take 12 weeks of bonding time for 20 weeks with 4 weeks unpaid. I like the way this person's thinking with this question. And this is actually another one of the kind of weaknesses in California law. So that California Family Rights Act that we were talking about, which lets somebody take 12 weeks off in a year and know that their job is safe, they can use it for bonding or they can use it for family caregiving, but it's only 12 weeks total in 1 year. So somebody who experiences multiple events is still going to be limited to 12 weeks. So if you had a significant injury in the first half of the year and you used your 12 weeks, you might not have any time left to bond if you have a child later in the year. And the paid family leave, 8 weeks, that is also just once in a year. So that's another thing that we can think about, maybe advocate for in the future, to recognize that sometimes people just have a really bad year, but that doesn't mean that they should have to lose their jobs or that they should have to go without income. In terms of somebody taking time off to care for a partner who's given birth, or another family member to care for somebody who's given birth, if they have a serious health condition and the person who gave birth, their healthcare provider, says that they need care, then a loved one might be able to take job protected time off and potentially get paid family leave income to care for them and to support them. Okay, another great question I'm seeing is, how many family members can receive paid family leave for the same care recipient? So as it's currently set, you can't have multiple people receiving paid family leave to care for somebody like in the same hour. But if, for instance, somebody requires around-the-clock care, it's possible that 3 different family members would each be taking 8 hours of time off, receiving 8 hours of paid family leave to care for that person. But you can't have 2 people receiving paid family leave income to provide care simultaneously. Looking at the questions. Let's see. So another person has asked if there's a limit to how many people can take job protected leave to care for one person at a time. And there isn't a limit, but the healthcare provider needs to certify that the care recipient requires the care of their family members. Let's see. So many good questions. Okay. And we're going a little over. I'm happy to keep going for a little bit because you all have so many great questions, but I just wanted to thank you all for taking the time to join us and to learn about these rights because we think they're really important for families and patients, and we hope you'll share the word. And if like your team or you know other folks who could benefit from a training, really do feel free to reach out to us or feel free to share this recording. Let's see. One question that we get frequently is whether taking time off for pregnancy impacts the amount of bonding leave that somebody can take. So we did touch on this, but I'm always like to emphasize it. And because in California we have pregnancy disability leave, which is time off specifically for somebody's health, and then we also have California Family Rights Act leave, which is time to bond. Taking time off for somebody's health does not mean that they won't be able to take time afterwards to bond. They're two separate entitlements and two separate chunks of time. So if somebody needs time off for their health related to their pregnancy, they should take it because just the fact that somebody works up until the day they give birth doesn't mean that they're going to be disabled longer after they have their child. And I think we have time for one last question. Sharon, do you want to suggest a last question based on your good review of the Q&A section?
Sure. Yeah, there's a question about what happens if an employer refuses to accommodate a pregnant worker, and especially if a worker has a physically demanding job.
Yeah, no, that's a good one to highlight, and it does come up a lot. I think that's a good time for somebody to give us a call and we can talk through strategies. Sometimes a medical note can be helpful. Sometimes sharing government resources can be helpful. Employers do have an obligation to see if there's a way that they can accommodate that employee so that they can continue doing their job. If they can't continue in their job, employer also needs to look to see if there's a way that they can be transferred. And then if they just aren't able to do their job, they might qualify for leave as an accommodation. So if it's for pregnancy, we talked about everybody's entitled to up to 4 months. So maybe they'll take more of that time as they continue to recover or during that time that they can't be accommodated, and they'll be able to get disability insurance if they can't perform their job. If it's later on and it's not related to pregnancy or childbirth, it's a little bit more of a balancing test where employers need to provide accommodations, which can include time off, unless they can show that it's really difficult for them to do that. So thank you everybody for joining us today. Feel free to reach out with your questions. We'll try to follow up with some answers, and feel free to reach out anytime. Happy Wednesday and take care.